Hello, I'm Stephen Ducey, and in this video today I will be going over terms of use presented on a website. We are specifically going to be looking at Priceline.com and its terms of use agreement. In this video, I'm going to answer 4 questions based on their terms of use. The questions I'm going to be answering are: is their user agreement a valid contract? Are visitors bound to it, or should they have to click an I agree? If you have a dispute with Priceline, can you sue them? Why or why not? And finally, what changes would I recommend? These questions will display the effectiveness of Priceline's user agreement and changes or recommendations that can be made to improve it. By using research and looking at what other companies are putting into their user agreements, along with what some experts say on what should be included in user agreements, will help Priceline in areas they may not already have in their own. The first question we will go over is if Priceline's user agreement is a valid contract. First, let's answer what a contract is, which defined by according to Merriam-Webster as a binding agreement between two or more persons or parties, especially one legally enforceable. For a contract to be valid, there are elements in the contract that must be met in order to be valid. According to Cornell Law School, for a contract to be valid and legally enforceable, it must meet the requirements stating that it's mutual assent, expressed by a valid offer and acceptance, adequate consideration, capacity, and legality. When looking at Priceline's terms of use, it meets the requirements needed for a contract to be valid. A clause that caught my eye when reading through the user agreement is that Priceline has a section that goes over their mandatory arbitration thoroughly, explaining what to do in a legal dispute. By reading over this section, users will have a great understanding of Priceline's process during a dispute and how to file a claim. Answering if the user agreement is a valid contract and the elements required for it to be valid is a great transition into the second question of how visitors agree and are they bound to this contract. The second question I will go over is if visitors are bound to the terms of use by merely being on the website or having to click an I agree. This goes into knowing the difference between clip wrap agreements and browse wrap contracts. According to the readings from this week, clip wrap agreements refer to agreements that obtain the user's affirmative acceptance electronically, and browse wraps is defined as an agreement that claims to bind the user of a website merely by the user's use of a website. Priceline's terms of use states, before submitting an account registration form and/or using any services on the site, please read this agreement carefully. By accessing any area on the site, users agree to be legally bound without limitation, qualification, or change and abided by these terms and conditions, which will constitute our agreement. From reading their terms of use and knowing the difference between click wrap and browse wrap agreements, Priceline is utilizing a mix of both. Unless the user creates an account and or uses a service, this is the only way the verbiage can be considered as a clip wrap agreement. From the wording used, it comes off that their website uses more browse wrap agreements than click wraps. Going more in the browse wrap agreement direction can have more issues arise for Priceline, with visitors not fully understanding or knowing the terms of use agreement. According to an article on termsfeed.com, they talk about browse wrap agreements as usually not being enforceable compared to click wrap agreements, and provided previous companies that have had issues with this in the past. In the article, the example they referred to was Zappos customers' data security breach. They stated, the court found that the browse wrap terms of use Zappos was not prominent and that no reasonable user would have read the agreement. Users may not read the terms of use if they don't have a reason to sign up for something where they then do not know and understand what they're agreeing to. This could bring more risk for a company that uses browse wrap agreements as opposed to clip wrap agreements. This brings us to our next question of if a user has a dispute with Priceline, can they sue them? The answer to this question is yes. A user can sue them over a dispute, but there is a process written in their terms of use. In the agreement, they mention that the user agrees to first allow Priceline to resolve any claim, where if that claim is not resolved within 60 days, the user may then look to arbitration or small claims court. Priceline has a mandatory arbitration clause in their terms of use, which is written and there to prevent the user from pursuing a class action or similar proceeding. A mandatory arbitration clause is said to be a lot cheaper without having to deal with the courts, and an arbitrator is ultimately decides the ruling instead of a judge and jury. This may be good for the business and looking out for the best interest of Priceline, but it could hurt the user who is attempting to make a claim. Arbitration is something that can go a few ways. According to an article on legalnature.com, where they discussed the pros and cons of arbitration, they stated the arbitration agreement has the potential of being one sided. If you are not the party that has written the agreement, you may find out later that it was written in a way that favors the party who initially wrote it. With Priceline having a more browse wrap approach, where users do not get to electronically accept, along with not reading the terms of use agreement and seeing the arbitration agreement, could hurt them when it comes to a dispute. Now, with the last question of what changes I would recommend for Priceline that will improve their terms of use. The first and probably most significant change that I would recommend is the clip wrap agreement approach. This approach will make their terms of use to be more easily accessible to visitors and allow the visitors the chance to read and choose for themselves if they agree with what they are reading. This is also a way to enforce what is written legally with the user knowing and agreeing to the terms. There are multiple cases in the past that help explain why using clip wrap method would be better for Priceline in protecting them and making their terms of use more legally binding. In an article on termsfeed.com, they referenced an importance of using clip wrap with the case of Forrest v. Verizon. In this case, the customer had a dispute with Verizon about a clause in their terms of service. The customer had to agree to the terms of service before continuing the transaction, and it was noted that the checkbox was small and the terms of service were long and difficult to read. In the article, they stated, in spite of those factors, the appellate court disagreed with the customer and determined they were provided with ample notice. While the terms of service might have been long and difficult to read, this case is a great example of how it necessarily wasn't relevant about what was written, but that the customer had agreed to the terms making it binding. Whereas this might have been different if they were using a browse wrap agreement. Another thing that I would recommend Priceline to do with their terms of use is to make it easier to read. Right now it is very technical and looks like a lawyer wrote it, where most people that aren't familiar with reading documents like that would have a hard time understanding what is written. In an article by Laura Caruso, she discusses ways to make terms and conditions more customer friendly and the importance of having a good readability score. In the article, she states, if score languishes around 30 to 40 mark, chances are your customers are struggling to understand them. She also recommends having a score around 65 or more. To check their scores, they use a site, thewriter.com, which provides a readability score. I tested Priceline's terms of use readability score, and they scored a 29.3, according to thewriter.com. That score shows that their terms of use may be difficult to read and understand for the normal reader. These recommended changes above will help improve Priceline's terms of use and the visibility of the terms of use. Thank you.